Okay, so let's talk about writing legal memo. Has everybody seen the problem? You found it no problem? I'm going to probably explain things or talk about things randomly differently for the recording as well, because what you see looks different from what the OUA peeps see. So, basically, I hate to tell you this, but there is no one right way. There is no formula that you can just follow in order to write a memo and get it absolutely perfect the first time, or any time. But there is a pretty good way, and I'm basically going to try and talk to you about how I approach writing legal memoranda in the real world, because that's what we're trying to replicate in this circumstance. But no matter how many things I say here, at the end of the day, in a choice between substance and form, I want you to pick substance every time. It doesn't actually matter what you write. What matters is what I read. In any communication, it doesn't matter what you say, it matters what people hear. And so there is no one right or wrong way to do it, but there are a few conventions that we can talk about, and a few rules of thumb. One of them is, think about the purpose of any piece of writing. What is it for? There are some natural constraints, numbers of words that you can use, or before you get penalised, what you're supposed to be writing about, the fact that you have to use words. Interpretive dance is absolutely impossible to get through Turnitin. You can use images if you wish, but at the end of the day, I need something that I can mark in the normal way. But think about, what's it for? And what is a memorandum of advice for? Why have you been asked to write a memo in this particular case?
It's like a brief.
Sorry?
Brief.
It's like a brief?
Yeah.
Yeah? Expand?
Or someone can read it quickly.
Somebody can read it quickly, they can understand. So this particular memo, so Dennis, does everybody, I assume everybody's got a picture of Dennis in their head. You understand who Dennis is. Why does Dennis want you to write a memo?
So that he can make a decision.
So he can make a decision. So it goes into a meeting informed. Any other reasons why he might want you to do that?
So you can have a summary of research on
He
the...
wants a summary of the research, he wants to know what the issues are, he wants to go in and be sensible in a meeting. Let's face it, he doesn't want to do the work himself. Okay, the memo is the tip of the iceberg. It's going to summarise the research that you did, the findings that you made. In order to get there, you're probably going to have to explain what the issues were and why it was important to research them in that particular way. But it's going to give Dennis enough information for him to go into a meeting sensibly and have a sensible conversation with somebody, with his client, about what the anticipated issues are. In the real world, and I'll put it the other way around, at university, if you get something 80% right, you will get a high distinction. You can show your transcript to your mum, she'll probably make you a chocolate cake and tell all of her friends what a hero you are. In the real world, you give a memo to Dennis that is 20% wrong. Given that Dennis is probably not the world's greatest supervisor, he will just trust you and not ask other questions. And he will then get sued by his client, you will lose your job, he will probably lose his practicing certificate. So in the real world, being able to write a memo of advice to your supervising lawyer is a really important thing. In the fake world of university, when I ask you a question, I usually know what the answer is already. At least I have a good idea. Sometimes people convince me that I'm wrong, which that's quite a joy when that happens. In my working life, when I ask a staff member a question, I don't know the answer. Because I can't afford to pay people, well, I probably can afford to pay people, but I don't want to pay people to do work that I can do myself or to answer questions that I already know the answers to. So actually reading a memo as a lawyer, as a supervising lawyer, is a really important thing, because part of what I'm doing is sense checking. I'm thinking, okay, I don't know the answer to this question, but it's important for me to know, like I already know if I had to do the work myself, these are the kinds of cases I'd look at. This is the kind of research that I would do. So I'm sense checking what my staff are writing for me to also see, well, if they looked at the same thing and then looking at the logic that they use, do I come to the same result? Now, in the real world, when my staff are writing a memo or they're doing some research for me or whatever, I would hope that rather than get stuck and get really upset about things, they would pick up the phone and they'd say, Kath, can you have a look at Carlisle and carbolic smoke ball? Have a look at paragraph 94. I'm reading this to say X. What do you reckon? And we'd have a conversation about it. Now, as supportive as I'd love to be of all of you, I don't have the time or the capacity, and it's not fair for me to do that level of interaction with you about the problem when we're going. So it's not going to be an exact replica of a workplace task, but it's a pretty good one. And I want you to think about it from that point of view. Assume that your reader doesn't know anything. Assume also, I think it even says in the problem, that the Law Institute's got somebody looking over Dennis's shoulder. That's why I get to read these questions. Dennis also needs to keep his file in order. If ultimately he does get sued because you got it 20% wrong, I'm not expecting that to happen, by the way. It's a very unkind analogy. He needs to have a file that demonstrates that he or somebody in his firm has done the work. So that's part of what the memo is for, keeping that record of what they did to get to the conclusion that they got to. So thinking about what something's for impacts thinking about what the structure of it should be. What is it that you're trying to communicate to your audience? And so as you think about what the purpose of your memo is for, that will inform you about how you, what the reader's needs are, what kind of language you should be using. So think about this for the moment. Who's the audience for this memo? Who's going to read it?
Dennis.
Dennis, exactly. So whilst I have cast some aspersions about Dennis's skills as a lawyer, do we think that we should be writing this in plain English, or do we think that we should be writing it in language using technical legal terms? Technical legal terms are quite appropriate. So we can use a word like consideration, for example, and assume that Dennis knows what consideration is. Where if we were writing to a layperson, to one of Dennis's clients, saying to that client, well, as you know, in order for it to have a contract, we need to have, do you remember what they are? Offer and acceptance, usually equaling agreement, consideration, intention to enter into a legal relationship and certainty. That all makes sense to Dennis. He might have forgotten the steps, he might have not remembered the cases, all the rest of it, but that all generally makes sense to him, as it's starting to make sense to you too. But if you write to my mum, that's meaningless to her. She has no legal background. That's not going to tell her anything, and you need to find other ways to do that. Does this mean, when we're using technical legal language with Dennis, that we need to make sure that we use long words? We might use that, words like hereinto, before, therefore, hence, with. The writer says in paragraph 3, blah, blah, blah. I'm seeing you shaking your head there saying, please no, don't make me write like that. I don't want you to write like that. Just because you're using technical terms doesn't mean that you don't keep the reader in mind. Your reader is not a contemporary of Shakespeare. Okay? Your reader is not someone who regularly reads Dickens novels. Your reader is Dennis. He works in Coolaroo. He's a lawyer. He understands legal terms, but he also expects to be treated like an adult. So he expects clear, straightforward language where things don't get lost in translation. You need to think about what your instructions are. So instructions, that's a word that we use when we're talking about lawyers all the time. What do I mean by instructions? So I can't remember your name, so I'm looking at you thinking I should remember. Bishul. No, okay. What do I mean by instructions?
Instructions is like some advice about a particular process.
Advice about a particular. Instructions are usually a question you ask. There's two different ways that we use it in the legal context. One is a client instructs a lawyer to do something. Remember, lawyers advise their clients. We're very good at saying, yes, we went to the High Court and we had a big win. We didn't. Our client had a big win. We advised them, or we advocated for them, or we did both. But we did so in accordance with their instructions. So that's that use. In the context of an employee solicitor working for a principal, you do what your principal instructs, which is just like the orders that they give you. So, but writing to a memo to a client in particular, we need to be really clear on what the instructions are, what's in and what's out. That can be particularly tricky when we're dealing with facts. So you're never going to know absolutely everything that happened minute by minute. You got a pretty good blow-by-blow description in this set of facts, as it turns out. That CCTV camera transcript is very helpful, I'm sure, but you're very rarely going to know everything that happened. So you're going to need to make assumptions sometimes. So often, working out what your instructions are, identifying what the facts are. Often lawyers will provide a memo in draft initially, so that they can get confirmation from their client that their instructions are consistent, that they are actually only answering questions they want answered. Surprisingly, some clients don't want every question answered. So basically, this whole slide pack it draws heavily on some materials that I prepared a couple of years ago now for a group of junior lawyers in a large law firm about how to write a memo. So I need to acknowledge that. I thought about making a little bit more focused on how to write a memo to get really awesome marks at law school, but I don't really care what marks you get. I really care about you being good lawyers. So I've stuck with this. The thing that you need to have sitting next to you when you go through this slide pack separately as you're checking off, have I done the things that matter, or have I not done them because I've got a good reason for not doing them, is put the rubric, the assessment rubric next to you. Have a look at it, because that is quite explicit about what you need to do to get good marks. There is absolutely no magic to starting a memo. This is kind of the format that they look like. The actual problem that you were given is set out as a memo. Bill Gates gives you heaps and heaps of templates to use. Absolutely no magic at all. One of the things I've noticed a couple of times, which I'll mention out loud, is quite a few people use this, and they, on the demo that I've given you and on some of the templates, they come out with these square brackets around the outside. Very rare to see those in actual real life. That usually signifies that this is a precedent, and that's the stuff inside the square brackets is the thing that you replace with the real information. And so it just looks quite odd when you leave the square brackets around the outside. That's just getting used to how these things roll. Do you put in a table of contents? Completely up to you whether you put a table of contents in or not. Again, think about your reader. If your memo is more than about 5 pages, that's where you start to think about it, and at 10 pages plus, you probably want to have it. When you think about it, a table of contents is a really nice little summary at the front of a document that helps people know where to go. Some people are better at signposting than others. One of the things I'm constantly doing when I'm giving feedback is I'll read a paragraph and I'll read something and think, oh, but what about X, Y, Z? And I'll type in, what about X, Y, Z? And then 2 pages later, I'll get to X, Y, Z. And then sometimes I go back and just remove it. Other times I'm saying, maybe earlier on you should have signposted that you were going to talk about X, Y, Z back at that earlier spot where I left a comment, because that was a natural place for your reader to ask that question. Often, if there's a table of contents and I'm wondering whether or not somebody's going to cover that, particularly if they've generated it from useful headings, I can just have a quick look at the table of contents and work out what's going to happen next. Like I said, let Bill Gates generate it for you. Most of you are pretty early in your law degrees. now is not a bad time to invest some time in lynda.com or even YouTube and get some basic familiarity with using Word or Google Docs or whatever it is to make sure that you can use automatic references, generate a table of contents, use some heading styles to get that consistency. It's boring, you don't feel clever because you've been able to do it, but the investment early on will help you later down the track as you're trying to bash out much longer and much more complex things. For that reason too, those of you who, now EndNote is a real investment. If you're not interested in tech, I probably wouldn't bother. I'm really pleased that I've made an investment in EndNote, and so I've got my case records in there and I can pull things up and it's really useful. But having some sort of system for making sure that you're keeping your citations and things like that in order is really useful too. So using footnotes and endnotes in Word would be another thing that I would look at. And by the way, lynda.com, they provide lots of online courses. They're all free for university students. You can get them through the library online. You know, the only time I've ever been to the physical library here was when I got my library card. Like, you can get anything you need is online. If it's not online, then it's older than it needs to be, right? So that would be my advice. So, first part of a memo usually is providing some sort of introduction or background. I think of introductions as having a kind of triangular shape. In fact, I just should find the slide and add it in that I used this morning in a different class talking about writing an introduction. It's that time of year. I think that you sort of start with, what's the environment? What are we talking about? Why is that important? What have I got to say? Where are you going to find it? And a little bit about where I ended up. Often, particularly if you do this well, in certain places that I've worked, I have always assumed that my boss isn't going to read anything more than the first page. Now, I can promise you I will read more than the first page, but I have worked for people who will never read more than the first page. They're looking at that executive summary or that introduction at the top, and that's what they'll get, and then they'll move outside that and look deeper if they need it later on. Christy?
So, Dennis has given us instructions. How do we need to relay those things back to him to be clear, in terms of exactly what you've been asked to do?
So often it's what have you been asked to do piece. I would, given that he's given them to you in a memo, and I think it says this on a subsequent slide, I would just refer to his memo. Say, the facts are as set out in your memo to me of X, Y, Z, or something probably a little less obtuse than that. This is not necessarily an introduction, we'll get to it. It could be if there's a fact that you've got to make an assumption about, you might want to point that out, but at the moment these facts are pretty straightforward and pretty clear. It's not so much in the introduction that you want to deal with the facts. What you really want to do is, when Dennis reads the introduction, he really wants to know, headline, what it is he's going to tell his client. Who's his client? Taylor Deuce. Anybody recognise the context? Really? You just don't want to admit it, do you? There's too many men in the room. These are characters from the Gilmore Girls. This is all happened in... Honestly. Anyway, what can I say? So, when they actually go, and he goes and advises Taylor, what's he going to tell him? Taylor, you got a case, you haven't got a case. You got a contract, you haven't got a contract, okay? Now remember too, I am not asking you to talk about damages or the validity of his case. We're just really limited to the first couple of weeks of contract. So really, we need to know, is there a contract or isn't there a contract? So in identifying the scope of the instructions and the research, sometimes the client will say, I need this answered and I need it within 24 hours. So you are writing a sentence in the first part that says, we have not had time or the available resources to scour the paper records at the Supreme Court. So our research is limited to everything that's online and accessible in the databases in the time that we've had. That's it. So you limited by reference to scope. Here you've got plenty of time. These things, you're thinking about the way that it's structured. So facts we just started talking about. Oh, that's very small print, isn't it? At least they're close by and you can have a look at it. If you are going to summarise the facts in a memo, usually that will be when you get quite complex facts and lots of different bits of information that your client might think is relevant but might not be. Usually our second assignment in this subject, the instructions that you get or the bits of information you get are substantially longer. So there's been a little bit of feedback that apparently some people would much rather have a nice clear problem where they knew what they had to do than actually twaddle through lots of irrelevant guff to work out what the problem is. I'm so with that person. My life would be so much easier if that was all I ever got to do in the legal profession, but unfortunately sometimes it's very hard to work out what's relevant and what's irrelevant, and that's part of what you need to do in coming to the nub of what your question is. But this time I don't think there's too much that's irrelevant there, but if you think that something in there is irrelevant, you might want to say so. If you think there's some additional piece of information that you might happen to have some insights into unused tobacco costumes that I don't have, that you might like to share as part of that. Don't waste too many words about it if it doesn't go to answering the question, but feel free. If you are gathering facts from a range of different sources, be really clear about what those sources are. Usually the best way to work out what's relevant in a problem is to make a chronological list. Now, a lot of people, with the ones who are doing discussion board problems, often that is the easiest way to sort them out. I'm a big fan of the post-it note. Find the back of a door somewhere, write down each of the facts and start packing them up on the wall. This one happened, then this one happened, then this one happened, this one happened. Get your chronology sorted out and then think, okay, at what point was a contract made? At what point was an offer made? Was the offer accepted? Was it rejected before that was communicated? How do we work those things out? If there's some disagreement or some uncertainty, so I know Zita and Susanna has been giving some of you a little bit of issue over the last little while, so those of you who are doing that discussion board problem, sometimes you can really quickly jump to conclusions about what the facts are. So really be explicit if you're making an assumption about a fact. Think about that each time. So, and if there's some disagreement about the facts, so if one party is saying X and the other party is saying Y, you need to say so. You need to be really clear about what the uncertainty is and what the issues are. Because it may well be, once the facts are identified and are known, that affects the logic of answering the problem. In this case, you can assume that the reader has provided you with all the facts and you can incorporate them by reference. So the reader here is Dennis. You can assume that he's given you everything that you need to know. He's not interested in anything else. Another thing that you can assume is that when he says he's not interested in the consumer law, that he means it. Now, actually, if your real boss said that in real life, you might say, yeah, but I still think we need to look at the consumer law. I have no doubt that the ACL could well change the outcome. Might be consistent, might not, but it's absolutely completely relevant to this problem. I'm not going to pretend otherwise, but I don't want you to address the Australian consumer law. We're going to assume that Taylor knows all about that. He just has a particular interest in knowing what his common law position is. Because that's what I need you to do at this stage. So I've mentioned this word assumptions a couple of times. If you have a legally relevant unanswered question, then you will need to make some assumptions. So some of those assumptions might be, we haven't really looked at it, but capacity to contract. Capacity requires either a company with legal standing or that you are an adult of sound mind, not inebriated, not under the influences of drugs, etc. You can assume, if you need to assume something about any of the cast members of our merry play, you might want to say so. Now, don't make an assumption just to make it easy. So don't assume that Lorelei is under the age of 16 or is inebriated or whatever, just because it gets you directly to the answer that you want, and wipe your hands of it. Make a sensible assumption like you would in real life, but you might like to point out that if that assumption is wrong, you're going to raise some other issues. Now, you don't have a lot of words here, by the way, and I really don't want to send any of you, just because I'm using this as an example, down the path of starting to write about capacity. Telling you up front, this is not a question about capacity. I'm just talking about the idea of assumptions and using that to illustrate this. I would not waste a word on anything that you don't need to waste a word on. But if there are legally relevant things that you think you do need to do this on, then make it really clear that you've got some assumptions that you are making, and be really clear about what the impact would be if your assumptions are incorrect. Issues. Be clear about what the question has been asked and identify the legal issues. So by identifying what the legal issues are, you're essentially mapping out what your approach to the problem is. I like the irony of my sentence here where I'm saying briefly, clearly, simply, concisely, precisely and accurately do exactly not that. Like, that is a really long sentence. It's essentially saying all of those things. Be as clear and straightforward as you can possibly be. Try and break down each of your questions into your sub-issues. Think about seeing if you can make it into a list. Again, I know I try not to print anything because I'm such a big fan of the post-it note, but try actually breaking out into your different post-it notes and ordering your questions. How do these make sense? Think about it. It's a little bit algorithmic, really. If this, then that. If that, then this. Think about what the consequences are. Try and present each issue separately. One of the things that you will see in modern legal drafting a lot is that lawyers tend to have headings that are questions. What is the impact of, or what are the consequences of the flick knife being in the window? What are the consequences of Mrs. Carhill not communicating her acceptance of said offer, or the offer? Where did that said come from? That's just weird. Anyway, so think about putting them in as questions and answering them. An FAQ approach, apparently the FAQ is dead, it's all being replaced by chatbots now. So I want a chatbot. But that aside, think about the FAQ approach to answering the question. Clear, concise, relevant. Many of you will run out of words here. So think about the importance of each of your questions too. Organise your writing and your thinking to put the pivotal questions first. And if there are other issues that fall out of that, think about where you're going to give your priority. And then you get to what I think of as tentative conclusions. Why do I think they're tentative? Because unless you're Justice Keifel, and even then you want a majority of the rest of the High Court bench on your side, there's always the room for some sort of debate. Now your client ultimately, so Dennis as a consequence, wants to know, is this worth pursuing or not? Is there some action I could take? Do I have rights? Now there might always be some room for a manipulation or an alternative answer, but you really need to don't sit entirely on the fence. Never sit entirely on the fence. It's a painful place to be, but be aware what's on the other side of the fence and be very clear that you know what's there. All of these cases that we talk about, at the point that it went into the courthouse, both sides believed they had a chance of winning. Or at least it was worth pursuing the litigation for that moment forward. Often, you write your conclusion at the end. It's one of the last things that you write, but it is one of the things you want to present up front. So whether it's in your you might call it an executive summary, you might have it as part of the introduction, you might have it sitting with a heading all of its own, but right up front you're telling Dennis, this is what I think, this is what the conclusions are, and then the reason for reaching that is set out and followed. Now, and I know, again, like I said, I often assumed that my boss would never read more than the first page, especially when I was general counsel and I'm working with a really busy CEO. I'm putting everything that matters on that first page. It's not even in the first couple of pages. I make sure, because I know, in fact, he never really printed anything out, so I needed to make sure, based on how big the font was on his screen, that he could see it without having to scroll down on the email viewer, right? Because that's getting his attention is that hard, which is fine. I'm thinking about who my reader is, but it's also really great discipline for you to pull together on the front page, these are what the key findings are, this is what's important, and then we go to how you got there. Often this bit, the conclusion in a law firm, is the bit that we extracted out and put into their knowledge database and used as a way of helping other lawyers later find a similar advice on a similar issue. So often that conclusion part in an internal law firm is a really important thing, and some law firms will have quite specific about the way that they want you to do that for that reason. Two things about the conclusion. You don't need to reiterate your legal analysis there. You need to tell me or tell Dennis where you got to. You might want to signpost where the complexities are, but you're not repeating what you've done somewhere else, even if it falls below. At the same time, don't put anything new in your conclusion. It's sort of obvious when you say it out loud, but you would be surprised at how often I see, sort of red, 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 and therefore red, pink, and really blue. Like suddenly we're talking about some whole new concept. Now, chances are what's happened is that somebody's been writing away and then they've decided to cull because their word limit's over and they've taken all of this bit out, but it sits there in the conclusion. But yeah, if it's important enough to be in your conclusion, it needs to be somewhere in your logic flow. You're looking like stunned mullets at the moment. Is everybody feeling comfy? Questions, concerns?
I need more examples.
Need more examples. Now,
To look at a contract and follow these systems.
okay. Now, firstly, I'm certainly happy to give you examples of memos that have been written in the past. Obviously not to this question, to a completely different question. Happy to give you high distinction examples with a big fat caveat sitting over the top of them. These people are answering different questions from the ones that you've got. Okay, so they may have done it in a particular way for a particular reason. Secondly, this is not a form filling exercise. I'm going through a list of steps that I know work. It's not a one size fits all, but it's a one size that fits many. At the end of the day, to do really well in a subject like this, you need to be able to demonstrate synthesis, you need to be able to demonstrate some originality and flair. And so one of the things that often happens when I share examples is then people get disappointed because they're so similar to that example that they've done in the past, and that one got an HD, why are they getting credit? Okay, so you really need to be careful with the use of examples. So all these things, think about why, not what. but more than happy to share. There may well already be some examples in the face-to-face group. I'm not sure that there is in the OUA one, but I can certainly work on that. And if there isn't, I'll get them in there into that assessment area. But of course you realise that you'll be looking at a problem that's quite different, which also might have been written for a group that were quite likely further along in. So this is one of the earliest that I've had to deliver this assignment. For what? When's it due? End of week 4 or week 5? Yeah, it's quite soon. 12 days? Yeah, 12 days. So it's beginning of week 3, it's due the end of week 4. Usually it's due, I've got week 5 or 6. That's all right. The reality is, if you were being a summer clerk somewhere, a problem like this, you'd be expected to have an answer in the afternoon, okay? Now, I'm not suggesting that you just do it in an afternoon and hand it in, although there'll be some of you will end up doing that and probably do quite well. I suggest that you do a bit, think about it, spend a little bit of time doing a little bit of thinking music about it.
In terms of like references that we use, are we using like the main cases that are attributable to the facts
So,
and also the textbook and...
Yep. So we'll talk about referencing in a minute, so I will get there. But yeah, basically this is common law. So you'll be using cases to illustrate your answers and to illustrate the principles that you come across. I'm going to talk about legislation first. Here in this memo, I don't expect to see any legislation because you've been asked not to deal with the legislation at all. Now, there might be some reason why you just need to deal with it, and you are going to need to deal with others, and I'm not going to go to this level of detail with the next one, and that might deal with legislation. If a provision is critical to your conclusion, then you should include it verbatim in your memo. So rather than, I keep quoting Section 18 of the Australian Consumer Law to you, and you will have heard me already say, thou shalt not in trade and commerce act in a way that's misleading or deceptive or likely to mislead or deceive. Spoiler alert, that's not what the section says. Like, it's not exact, it certainly doesn't start with thou shalt not. I just treat it like a commandment. It's close enough, but it's not exactly what the section says. If I'm writing it, I would be getting the section as it stands now. I would be checking the section as it stood at the time that the relevant thing occurred. I would be making sure that if there had been a change in the law that I had caught that. If it turns out you're not talking about one section, you're talking about a whole lot of sections, you would want to attach that to the memo. Think about your reader. Now, one of the things I hate about AGLC, personally, is AGLC only thinks about readers who read on paper. It doesn't think about readers who read online, so it's not encouraging you to put hyperlinks through to the cases or sections or otherwise. And I'm not asking you to do that either. Turnitin doesn't actually have that capacity. I actually have to go and look them up separately. But I think that change will come in AGLC as we move forward. This sort of stuff, it's like if you're working with somebody like Dennis, who, let's face it, is not even particularly good with a photocopier, he's going to need a printed version of the memo, and he would be looking for all of the attachments, the cases, etc. I think if you were working for me, you wouldn't do that. You would put some hyperlinks in. You're working for Dennis, you would make sure there were copies of the relevant bits of the cases with it. Now, I don't want you to be giving me copies of cases at this stage. That's ridiculous. But you might be quoting some part of a judgment if you think it's relevant. Okay. So the discussion and the analysis. So you notice I've spoken about the conclusion first, earlier, because I want you to think about producing that up front. You'll probably write it last. So I'm presenting this information in the order that I would be likely to see it on your piece of paper. So in your discussion or your analysis, once you've identified what the issue is, what the relevant facts are, what you think the questions are that really needed to be answered and why they're important, this is where you really describe what the relevant law is, and predict how a court would be likely to resolve the issue. So what are you going to use to predict what the court is going to say? Even if your advice is don't go to court, this is ridiculous, these are Star Wars characters, for crying out loud. But you've got to think, well, what would a court say? And the only thing that we've got to go on is what courts have said in the past. We understand the doctrine of precedent, so we can look at other cases. So the easiest thing to do is to see if we can think of cases that have analogous facts. So can we think of another circumstance that might be similar here? You can use cases we've discussed in class, you can go to your casebook to do that, and you can even do actual research. What research tools did you talk about or have you used already in intro? Ostley, yeah, I heard Ostley. Jade, oh, you talked about Jade, good. On the 21st of September, I think it is, I've got Sue Ann Yap from Jade is going to come in and talk to you guys about using Jade. Partly because she's just a scream and you guys must get really sick of me after a while, but I think Jade's a really excellent tool, particularly when you're starting off with research, because of your ability to collaborate inside it. And a lot of the hyperlinking stuff and finding things, I just find it's much more, barristers use it a lot. It's not really particularly highly respected in the academic world at the moment. I'm not really sure why. I think it's largely because most academics type with two thumbs, but that's being unkind. But I thought that would be a good time to have her come in, because that'll probably be the week that I'm giving you feedback on this assignment and feed forward on the next one, which will involve a lot more research. So when you've actually had the experience of doing research in contract law, then if we actually go through and get Sue Ann to talk about the way that she would have done it in that platform, I think that will be useful for you. So, of course, you're saying, where is she now? I wanted to solve the problem now, but it won't mean quite as much to you before you've done it. So finding analogous cases, sometimes that is going to Ostley, Jade, LexisNexis, Thomson Reuters, any of those tools. Sometimes actually just having a go at saying, oh, can I find cases that involve supermarkets? Can I find cases that involved the wrong price on a sign? Where do I look for these things? So sometimes you have to be quite freeform, sometimes you will be quite specific. Also, as you think about different principles, and we think about the cases that might be relevant. So say you decide that Carlisle and carbolic smoke ball is a really relevant case in this particular endeavour. Also looking at cases that have cited Carlisle and might have involved a shopping centre or might have involved a dispute at the till. Seeing what you can find there. Those kind of research things will help you quite well. Sometimes you'll find cases that give you the answer that you don't want. A couple of things you can do there. You can ignore them. That would be stupid, but you can ignore them. You can distinguish them. So you can think, how is this case? I can see that this case is similar to what I'm looking at, but it's different in these other ways, so it should be distinguished for this reason. So you can distinguish on the facts. You might just say, well, this is just an errant judgment, it's different, and the better case law is this other one. Of course, you could change your mind and give your client some bad news. Just because they're our client doesn't mean they're right, sadly. And sometimes you have to, whilst we all need to act in the best interests of our client and we need to try and find a way to get them the best result that we can, we need to do so in an ethical and a straightforward way. So sometimes the cases will tell us that our client would be better off saying sorry, paying compensation, taking their bat and ball and going home. this is the way of the world. When you're looking at cases, part of what's important and a real skill that you'll really just be beginning at this stage is extracting and applying the relevant bits. So that was apply, not imply. And there's a real art to this, I think. A memo is not the place to set out all of the facts of Carlyle and carbolic smoke ball and talk about all of the principles in that case and then talk about how they're relevant to this case. You're really trying to find the briefest and clearest way to talk about what's relevant in this case, extract the relevant principle from the case that you're referring to, and saying how it applies to the circumstances that you're dealing with. And in that regard, the best papers will look always at both sides. They'll pick a side, but they'll look at both sides and they'll address the arguments in favour and against on each case. I don't need to go into this stuff in too much detail. These are very much written as a stack of notes that you can take and keep and do what you will with. And so not everything on them will be relevant to this particular assignment. Ultimately, a lot that happens with legal memoranda is it's about giving an opinion on what you think the state of the law will be. And if you're looking at something that is ultimately more complex and more nuanced, this is largely a black, and well, it's not entirely black and white case, but doesn't involve a range of different complex issues. Often you'll be in a position of grey. Whether it's light grey or dark grey, you might have a view, but you won't be able to say with absolute certainty. So you're needing to give your client some sort of sense of how strongly how strong you think that, or weak their position might be. Is it worth a fight or not? Where people get really good marks in writing memo and writing advices generally is if they can support their reasoning. So it's about being logical. It's about undoing the fact problem, undoing the puzzle, and then reconstructing it. Some of the things that really help people to shine is thinking strategically too. Suggesting to Dennis some of the things that the client might like to think about doing, what the end consequence could be given what you think the position is. Don't always immediately assume that the next step is court or surrender. There are a lot of places between going to court and surrendering entirely. And so thinking about what other solutions there might be within reason, given the word limit and the task at hand, is really useful. Analyse each of the issues separately. Make it easy for me to give you good marks, in other words. Make it easy to extract the bit that deals with an offer, the bit that deals with consideration, the bit that deals with certainty if there is one. One of the biggest criticisms that I've had assessing these memos almost every time is that people look at it and say, okay, the question is about whether there's a contract or not. Tick. In order to have a contract, we need to have agreement, which is made up of offer and acceptance, or if we can find consensus ad idem. Okay. Then we need to look for consideration, then we need to look for certainty, and we also look for intention to enter into a legal relationship. All good so far. So I'm going to do 25% of my essay on the first of those, whether there's an agreement or not, and 25% on whether there is consideration or not, and 25% on whether there's certainty, and 25% on whether there's intention to enter a legal relationship. And a little bit of my soul dies. Because actually, chances are this problem is about one of those four things. So spend your time and energy where the interesting issue is, where the priority is. Now it might be over more than one of them, It's probably over more than one of them, but think about it proportionally. Also, if any of those fail, then we don't have a contract. So if one of them's dubious and one of them it's really very likely that it's failed, then deal with the one that's really likely in a particular way, and the other one you might deal with it and say, okay, well, we've got this and that, but if I'm wrong, I refer you over to what I'm talking about in the offer and acceptance, and that's really got us home, or otherwise. That's assuming that we're finding no contract. Now, it might be that you're finding a contract, see how we go. I mentioned signposting a couple of times. Headings are really useful. Again, I would say this with every piece that you write, make it as easy as possible for your reader to give you good marks. Make it logical, make it easy to read. Use sensible headings. So, especially if you're using a table of contents, if the heading is Introduction, Summary of Conclusions, Finding, Research, that doesn't really tell me anything. So they're good headings for you, but they're not really helping me as a reader make sense of what it is. So, but a heading that says, what should Taylor Deuce do next? Or what should supermarkets do next, or whatever they're called, that gives you some indication of what's happening in that space. If I had my way, a significantly larger proportion of your marks would go to your ability to use the English language. Because being able to write well is the tool in trade of all lawyers. And the reality is, when only a small percentage of your mark goes to your written language, people who don't write particularly well can actually do very well, which I'm happy for them, but at the end of the day, I'm sending you out into the world to be lawyers, and there is an expectation that you will be able to write well and clearly, and it is absolutely a fundamental skill that you need. So if you are having issues, or if you are not strong writing in English, even if you're getting good marks, I would strongly recommend that you make an appointment with the Learning Lab and that you get some help in that regard. That you go back to basics, that you make sure that every paragraph has a topic sentence, that every paragraph is really only one key idea, that your paragraphs don't go on and on and on and on and on, that you break it up into sensible places, that you think about making and using active language. So the cow jumped over the moon, not the moon was jumped over by the cow. You're not using irrelevant, passive language for no reason. Often when you don't write well, it is harder for me to follow your arguments and your reasoning. And so, again, that impacts overall marks as well. Sadly, the other side to that is people who write well and their reasoning is flawed, it's easier to pick it up. Which always feels really unfair to me, but that's sometimes how it works. So just be really careful about language. It really is, I cannot stress more strongly how important it is to be able to write well. Not so relevant here. I'm not expecting to see, I'm sorry Dennis, I ran out of time. I'll tell you more on Thursday in a memo. You guys have got plenty of time. But in the real world, if there is a constraint, if there is some reason why you haven't been able to do everything, don't pretend that you have. Be ethical. Identify pertinent missing information and outstanding issues. So if you've made assumptions, or if there's something that you think needs to be followed up, if, for example, it is really worrying you that Dennis doesn't want you to look at the Australian consumer law or other legislation, put in a sentence about that. This advice is necessarily incomplete because we haven't examined the implications of the Australian consumer law. Before you speak to the client, I suggest that you look at that. That would be enough. Biggest question. Have you answered the question? One of the key things I would recommend everybody do, say get somebody who's not doing a law degree to read the question, and then you tell them what you think the answer is and why. Obviously in layperson language because they're not lawyers. A couple of things come out of that. Record yourself if you want to. It can be a little bit petrifying, but it's not a bad thing to do. You need to organise your thoughts to explain something that is relatively complex to somebody who has no background. That will help you when you've done that to organise those thoughts for a technical person as well. If you have an interested friend, they will ask you questions, and that will help you work out where you've missed something, where you've just filled in the gaps in your own head. Sometimes that'll be because they're things like, well, what's consideration? Well, you know you don't need to really explain what consideration is beyond a certain point to Dennis. Okay, you can use that language, you don't need to use another substitute word. But they ask another question and you think, okay, maybe I haven't explored that issue well enough. So I think that that's really useful to do. I also recommend, I don't know if it's on the slide, that you read your work out loud. Even better, that you get Siri or Cortana or whatever the Android voice's name is, Alexis, is that her name? To read your writing to you. Our brains fill in the gaps. Spell check will not tell you that manger is an error when you meant to write manager. Your eyes won't necessarily notice that either because you know what you're expecting, but Siri, Alexis and all of her gal pals, they will read it exactly as it is read. It'll be robotic, but the punctuation, the grammar, everything will be, and you can listen and you think, okay, that just doesn't sound right. If it doesn't sound right to your ear, then chances are it's not written in a useful way. And that's particularly useful for people whose first language is in English. But frankly, it's been years since any major piece that I write that I haven't gone through and done that. Although I wrote a piece for the Law Institute Journal last month and did exactly that and sent it in. And oh no, they sent it back to me and I just listened to it. Thought that sounds all right. They spelt my name wrong. Because Catherine, my spelling, and Catherine, the other spelling is the same. So I got caught. Still, I still think that's their fault, not mine, because I don't actually think that was in there. But anyway. Sources consulted and research checklist. Now you have to use AGLC 3. You have to include a bibliography that is formatted in AGLC 3 style. Think about what the headings are, have a look at what AGLC 3 looks like, think about the formatting. Your reference list needs to include everything that you have looked at, not just everything that you have cited or quoted in the body of your references. Why? Why would I want that?
To show we're not cheating.
That's why Tentative wants it, to show you're not cheating. But also,
Check on
I'm
research.
sense checking, okay? I need to know the source of where this information has come from. I believe you're sensible people. If you haven't quoted it, it's because it's not relevant, it's not necessary, but at least I know you've looked at it. Okay? At least I know what direction your research has taken you. This particular slide is probably more, the last bit I've added here, but probably more focused towards lawyers in law firms. Usually, reference list, mostly, particularly in big and complex matters, we'd be wanting to see the references related to an issue, because as different teams get isolated out to work on different specific issues, we want to just make sure that we've got all of the references in one place. Also just trying to make them as useful as possible, including hyperlinks, etc. Here, don't worry about that, use AGLC. Unfortunately, sometimes too, in that little piece in the criteria that looks at presentation, referencing is one of the elements, and sometimes people write really well, and then when they're not using AGLC properly, it makes it very hard for me to elevate them to the next level. I think I said this last night in the tute. I have a very Catholic approach to marking. None of you will lose marks for anything. You only gain marks for doing awesome, right? You all start at 0, and you have to earn the marks from there. You don't start at 100 and lose marks for mistakes that you make. You start at 0 and you achieve marks for the awesome that you do. So sometimes it can be very hard for me to elevate you to the next spot for silly things like AGLC. In relation to word limit, I know every group is, every class has been quite explicit about what the consequences for going over or under the word limit are. My view is that being able to write precisely and concisely is a skill that lawyers need. I do my damnedest to make sure that I've got a problem that can be answered within the word limit in a sensible way. Some people will go over. If you're going over because you're repeating things or you're writing in a flowery way or doing stuff that's unnecessary, ultimately you won't get as many marks in relation to the presentation elements as you otherwise might. Some people will go right over, but because they're not doing that, they might end up in a situation where they're losing marks for, now I'm using losing marks terminology, they're failing to achieve marks because they haven't made judicious choices about where to spend their energy. So they're doing that 25, 25, 25 thing. Think about making the choices in that way. Some people might be over and their papers are close to perfect. They probably won't lose marks at all. So think about it that way. If you are way under, if you are concise and precise, you'll probably do quite well on the written English part of it. But my guess is if you're way under, you've missed an issue. Or there's some key part there. So where you won't gain marks is on the reasoning and legal logic side, so the content side, which is 70%. And that's where you really want to get as many marks as you can in that part. Appendices, I'd be very surprised to see anybody add an appendix to this. But essentially they're the things that you add onto your memo that support it. So I spoke earlier, for example, about legislation. If you needed to attach a couple of pages of the legislation, you'd do so as an appendix. So make sure you get them organised. Language. Verb tense, I've spoken about this a couple of times. Most guidelines suggest that you state facts and court decisions in the past tense. The stuff that happened in the supermarket happened in the past, so we write about it in the past tense. If we're talking about what the rules are, we talk about them in the present tense. If we're talking about what they were in the past, because they've changed since, then we could talk about them in the past tense, but what they are right now, we're using the present tense. Makes sense? Recommendations, what should Deuce do, or what should Dennis do? Well, he's going to do those things in the future, so we talk about them in the future tense. General rule, pay attention to what tenses you're using and use them consistently. And think about in each paragraph how you word that. When you get multiple tenses in a sentence, that's just difficult to read, and we lose track of the point that you're making. Think about the word choices that you use too. Ultimately, in a letter of opinion or a memorandum, this is your opinion. It goes without saying that's your opinion based on your consideration of the law and the facts, that you have thought about it, reflected on it. It's a considered conclusion. So saying I believe or I feel or maybe or dare I say it's the vibe, probably not appropriate here, although it's the vibe is in this sense probably appropriate occasionally. I'm leaning towards I think maybe, what do you reckon? No, we need your opinion. If you haven't figured out something, say so. At the end of the day, you need to be ethical and honest about your position. If you don't know something, be clear about it, particularly in the real world. If you need to continue to investigate, say you're still investigating. I expect your investigations to be complete, by the way, for this particular piece of work, but that in the real world you can't always do that. And if you need something else from your client, so this is where it would make sense, can you please ask Deuce about A, B and C? And when we know the answers to those questions, then we would investigate D, E and F. And if F is actually blah, 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 then X, Y, Z is likely to apply. But if it isn't, then Carlyle and carbolic smoke ball will results in the position being whatever. Make sense? Talk too much. Really useful. I love this quote. It is from an American, but I'm going to read it verbatim as well, because I just love the way it's written as well. Avoid legalisms. Latin phrases, abbreviations and other legalisms are the badges of legal writing. However, they are commonly redundant, usually pretentious and invariably unnecessary. When legalisms punctuate a paragraph, readability suffers. Like lavish capitalisation, frequent exclamation marks and underscoring for emphasis, legalisms serve as crutches when plain English would nicely suffice. The addition of supra, arguendo or inter alia rarely amplifies a thought. There is an irony there that I enjoy. Citations, get them right. Get them right. Think about readability as well. So think about where you put the citation. Think about whether you need to have the whole case name in the text or whether a footnote will suffice. One of the things I want to point out, particularly to people who come from a business background, let me just see if I can do this. I just want to actually highlight it here, is oh no, it's going to be too hard, sorry. In AGLC citations, we have the year of the case in brackets. Those of you who come from business background and are used to citing in Harvard are quite familiar with seeing in-text citations with the names and then of the authors and then the year. In AGLC, we never have the year just hanging out there by itself. We either have the year with the whole of the citation or we just have the case name. Okay, so particularly first assignments, I regularly see case name, year and nothing else. Case name, footnote, year and the rest of the citation in the footnote, that's a tick. Case name, year and the rest of the citation in the text, that's a tick. Awkward to read, but it's a tick. Case name, year, footnote, rest of the citation in the footnote, that's cross. Jack.
I think you just answered my question. So the first time we write a case, the first time we're mentioning a case in the text body, do we have to do the full citation, or can we just do the name and then footnote?
I've got to remember what AGLC says. I'm perfectly comfortable with the name of the case and a footnote that leads to the whole citation, and then subsequently the ibid or the opsit with the above n. So not opsit, we're not allowed to use that anymore. It's above n, which is look above to the n with the footnote number. That's fine. Think about the way that it's readable too. So again, another benefit of putting the headphones in your ears is that you will read, it's like, as said in place of development, blah, 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 blah. I was like, oh, really? Let's just get the principles out there as quickly as we can. So I find I like this approach better, the second one, to say it's clear that every contract needs consideration in place of development, blah, 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 as opposed to case and then what the consequences are. Again, it's sort of a rule of writing, isn't it? We put the most important stuff at the beginning. Try and avoid string citations too. AGLC doesn't allow for like one sentence and then multiple footnotes. Try and, if you're going to have a lot of cases or articles or whatever it is to support something that you're saying, put them all in the footnote rather than have multiple cases in the body of the work where you can. Yeah, and you've got to remember too that they're actually quite hard to read. They're quite hard on the eye because you're changing the formatting, which you need to do. Remember, the case names need to be formatted. Latin phrases, if you're using them, need to be formatted unless they're already in the Macquarie Dictionary. You've got to go and check those rules. It's probably not the most fun thing you'll do, but you need to do it. Lawyers love footnotes too, by the way. Footnotes don't get caught in your word count. So footnotes can often be a really good way to sneak in that extra bit of juicy information that you were desperate to tell me about, but you were running out of space. Do so with some caution. Some people are of the view that, particularly in letters, I must admit, and in letters I agree with this, in letters to non-lawyers, that we shouldn't have footnotes at all. That when you are writing to a client, the client deserves to get all of the information. Footnotes to me feel a bit like whispering. You know, I'm telling you some piece of information, but by the way, there is all this little aside stuff that I'm telling you down below in little small print. If it's important enough to tell your client, I think you want to summarise it and get it into the letter. But in a memorandum, particularly where you're dealing with another lawyer who may not be the world's greatest lawyer, you don't know what they remember and that they don't remember, maybe using a footnote to provide some guidance in relation to a particular issue or to point out something interesting, I think is more useful. Again, think about your reader. Generally, many legal writers use a lot of quotations. On the whole, you should try and use your own language here. One of the interesting things about Turnitin is it's really not set up for AGLC, so it's looking for double quotation marks, and if you are quoting appropriately using AGLC, you will rarely use double quotation marks. Long quotes will be indented and won't have quotation marks at all. Shorter quotes will have single quote marks, all of that sort of stuff. So you'll find your Turnitin scores, particularly if you're used to coming out of other environments where you've used Turnitin before and it's really happy with Harvard, it knows how to use Harvard, you'll find that your Turnitin scores go up. Don't panic, okay? I can actually tell the difference between what you've done well that a robot hasn't noticed and that I can notice, so don't panic. The other thing that you'll notice is because you're all answering the same problem, those of you who submit later will have higher Turnitins than those who submit earlier, because there'll be common words that keep coming up because you're dealing with the same problem, you're referring to the facts, all the rest of it. Again, don't panic, I'm not an idiot, I will be able to work those things out. But at the end of the day, don't devalue your own words either. What your boss is looking for is your take on what these problems are. So you use your own words, practice doing that. Stringing together a whole heap of other people's quotes is not particularly useful. So when you're referring to case precedents, summarise or paraphrase when you can. If you need to quote, be precise in electing what needs to be used and what can be cut. And then when you finish, always ask yourself, have I answered the question? Have I answered the question? Have I answered the question? Gee, that took me a long time and you didn't even have a lot of questions. Can I answer your questions now? Questions? Check.
Just to confirm, it's you on the 12th, Saturday night?
You're on Sunday night, surely.
12th is Saturday.
Really? I would have thought it would be due on the Sunday night.
Does
There might have been a clash.
Sunday on the due date, Sunday week
We had a problem with the way that it was written. Remember, you had to actually give me your. So OUAs are due on the Tuesday night, and you should be due on the Sunday night at midnight.
The 13th.
That's the 13th. That's my mother's birthday. That's probably why I didn't do that. I'm happy with the 13th. We've talked about the Sunday. I know the words say the Sunday. I will do a clarification. Sunday.
It says 12 on there.
It says Sunday the 12th, does it? It just says 12th.
It says Sunday the 12th of August.
Okay, it's Sunday the 13th of August. It's meant to be the Sunday at the end of week 4. That's my point. Thank you for bringing it to my attention. I will fix it. Okay, so can I actually just say something about time getting it in? I have very limited ability to give extensions. Policies for extensions are quite clear. I can give you an extension if an unexpected circumstance arises, something that you didn't know about. Your illness of one of your children, family emergencies, things that you couldn't have planned for. So your wedding, your holiday, your anniversary dinner, these things are not unexpected circumstances. The birth of your child is often not an well, it can be unexpected, but you've usually got a little bit of planning time. So I do need, if you are going to ask me for an extension, could you please be respectful enough to put in your request the unexpected circumstance that you're asking for, or the reason, so that it makes it easy for me to do that. You might not be expecting it to take so long. That's not good enough, okay? So I need so have a look at the policy, make it easy for me to comply with the rules if you're asking for an extension. And if you need an extension. Don't ask for an extension unless you need one. Because you're really stealing from time later in the semester, and it's only going to get busier, okay? We are going to keep moving faster and faster. We're almost at 7 o'clock now, and we've got a lot of stuff to cover. So don't ask unless you need it. All of the assignments in this subject, regardless of the mode you are doing it in, are due at 11:59 p.m. Once it clicks over to midnight, you will lose 10%. If it doesn't get in by 11:59, you will lose 10%, whether it is a minute late or it is 23 hours and 59 minutes late. The reason for that is you will not make it 11% better at 2 in the morning. So think about it. If you are writing a piece, you're about to get, let's say, a credit for it. So 65% is where it looks like it's sitting. You are not going to make it 6.5, well, more than 6.5 points better in the next few hours. So I am absolutely, I think I'm probably pretty relaxed about most things, but I am absolutely rigid on that midnight. Now, if it turns out for whatever reason you are, and many of you will be submitting them in the late hours of that Sunday night, and Turnitin is down, or your computer's not working, or something like that, you send it to me as a PDF in an email. You get it submitted the next day. I will compare to see if they are the same or not. But you just give me proof that it is done. Don't stay up until 2 in the morning. You have to come to this class the following night. I want you to get your sleep.